All right, 2021 Code of Virginia, Title 45.2, Mineral Mines, Minerals, and Energy, Chapter 16, Virginia Gas Oil Act, and we're on Article 2, Gas and Oil Conservation, 1613, Meetings of the Board, Notice of General Powers and Duties. All right, 1613, Meetings of the Board, Notice and General Powers and Duties. The Board shall schedule for the monthly meeting for the time of the place for the designated by the chairman and no petition for the action filed by the board prior to the meeting. The board may cancel the meeting. Notification of the cancellation of each meeting shall be given the written members for the chairman at least 5 days in advance of the meeting. 4 members shall constitute the quorum of the transaction of any business that comes from before the board. All determination of the board shall be by a majority vote of the quorum present of the board shall be the power that is necessary for the execute and to carry out all of the duties specified for the chapter of the board is authorized to investigate, inspect, record, facilitate the necessary for all and proper to perform the duties under the chapter of the board may employ personal consultant with the necessary for the perform of the duties under this chapter. 1613. 1614. Additional duties to the responsibility of the board. A. Executing the duties of the chapter of the board shall 1. Follow to encourage, promote safety, efficient with the exploration, the development, and production, conservation of oil and gas and oil resources located in the Commonwealth. 2. Administrative method of gas and oil conservation purpose of the maximize the exploration, the development, and production, utilization, gas and oil resources. 3. Administrative procedure of the recognition, protection of the right of the gas oil owners interested in the gas or oil resources contained within the pool. 4. Promote maximum production recovery of the coal without substantially affecting the right of the gas owner with the pro of the gas well with the exploit of the produced gas. And 5. Hear and decide appeal of the direct decisions and orders issued on Article 3. B. Without limitations, general authority, the board has specific authority to issue regulations or order pursuant to the provisions of Administrative Process Act in order to 1. Prevent the waste and design, spacing, utilization of wells, pools, and fields. 2. Protect correlative rights. 3. Interspacing pooling orders. 4. Drilling units. Establish drilling units. 5. Establishing maximum allowable production rate with the prevention, waste, and protection correlative rights. 6. Provide a maximum recovery coal. 7. Classify coal pools and wells as gas, or oil, coal bed, methane gas. 8. Collect data, make investigation, inspection, examine the property, deletion, paper books, and records required with the provider with the keeping of the records, making the reports. 9. Set application fees. 10. Govern practices and procedure before the board. 12. Require additional data for the parties to any hearings. 12. Take actions responsible and necessary to carry out the provision of the chapter. 615. Applicability and construction. A. The provision of the applicability of all the lands of the Commonwealth, whether publicly or privately owned, however the no well commenced prior to the July 1st, 1990, shall be required that it be plugged with abandoned solely purpose for complying with the conservation provision of this article. Being no provision of the article should be construed with the grant of the board the authority to power to fix prices of the gas and oil. Alright, 1616, statewide spacing of the wells. Unless prior approval had been received by the board with the provision of the field of the pool to allow with the not well with the drilled and searched well shall be located within 1,250 feet to any of the well complete with the same pool. However, the spacing requirement subject to 45.21612 of no well drilled with the search of the gas shall be located closer than 2,500 feet to any other well complete with the same pool with the closer than 2,500 feet to any of the storage well within the boundary of the gas storage field certified with the State Corporation Commission prior to January 1st, 1997, if the well is drilled with the complete with the same horizon certified with the gas storage field, and 3. No well should be drilled with close to the boundary acreage supporting the well with whether such acreage is single with the leasehold with the other tract the contractual statutory drilling unit, then 1/2 of the applicable minimum well spacing distance prescribed in this section. Unless prior approval that has received with the board a provision of the field of the pool rules allows. 1. No well drilled in search of the coal bed methane gas should be located closer than 1,000 feet any of the other coal bed methane gas well. Or in case of the coal bed methane gas well located in a gob closer than 500 feet to any of the coal bed methane gas located in the gob. 2. No coal bed methane gas should be drilled closer than 500 feet or in case of the well located with the gob closer than 200 feet with the boundary of the acreage supporting the well, whether such acreage in single leasehold or other tract or contractual statutory drilling unit. 3. The spacing limitation set forth in the section or subject provisions statute 45.2.16.11 and 45.2.16.12. 1617 voluntary pool of the interest drilling units validity units agreements. A, if two or more separately owned tracts with the embrace with the drilling unit, or if they separately own interest within all or part of any such drilling unit with the gas oil with the owners owning such with the interest may pool for their interest for the development of the operation of the drilling unit until voluntary agreement with such agreement that may be based on the exercise of the pooling right of the rights to establish drilling units with the grant of the gas or any gas or oil lease. B, non-voluntary pooling agreement between and among gas and oil owners shall be held held to violate the statutory common laws of the Commonwealth, of the prohibited monopolies or acts of arrangement, contract combinations, conspiracies, and restraint of the trade or commerce. 1618 notice of hearing standing for a form of hearing. Any person who applied for the hearing in favor of the board or pursuant with the provisions statute 45, 216, 19, 1620, or 1622 shall simultaneously be the filing of the such application provided in the commercial delivery service or return and receipt of the request of certified mail return receipt of the request of each of the gas, oil owner, coal owner, or mineral owner having interest underlying the track with the subject of the hearing with the operator with the aim of the gas storage field certified with the State Corporate Commission as public utility facility whose certified area would include with the track that is subject to the hearing whenever the hearing application is unable to provide such written notice because of the identified or location of the person to whom the notice is required is given is unknown. Hearing application shall promptly notify the board in such an inability. B, at least 10 days prior to the hearing of the board shall publish for the agenda with the newspaper the general circulation in each of the locality with the lands with the subject of the hearing are located. The agenda shall include the name of each of the applicant, the locality of the lands of the subject of the hearing is located, the purpose of the hearing, and the date, the time, and location of the hearing. C, the board shall conduct all the hearing with the application with the made pursuant to the form of the litigated with the issue of the hearing provisions of Administrative Process Act. The application with the person who pronounced the requirement to be given in subsection A shall have the standing to hear be heard, and the board shall render its decision on such application within 30 days of the hearing closing the date, and shall provide notification of the decision to all parties of the hearing pursuant to the provisions of the Administrative Process Act. Alright, 1619 Field Rules, Drilling Units, Wells, Hearing Orders. Alright, in order to prevent the waste of the gas of the drilling with unnecessary well of the project for the core of doing the rights of the board of the in its own motion, upon the application for the gas and oil of the owners that may establish modified drilling units to the extent reasonable possible. Split uniform shape of the side of the entire pool with any gas oil of the royalty owner may apply with the board establishment of the field rules of the creation of the drilling units within the field unless such motion is made with the where applicant is received in at least 30 days prior to the next regularly scheduled month. The meeting of the board shall be not heard by the board. Such meeting shall be heard by the next meeting of the board thereof or thereafter. Be it any hearing with the board regarding the establishment modification drilling unit, the board shall make with the following determination whether the proposed drilling unit is unreasonable, arbitrary exercise gas oil owner rights, explorer for ore or produce oil gas. 2, whether the proposal would either unreasonable interfere with the present and future mining of the coal or other minerals. 3, the acreage include the order. 4, the acreage of the embrace for each of the drilling unit in its shape. 5, the area in which wells may be drilled at each of the units. 6, the allowable production of each wells. C is establishing modifying drilling unit with a coal bed methane gas in order to accommodate with the unique character of the coal bed methane development of the board shall require with the drilling units comply with the mining of the development plan with if it requires for the coal operator the wells paid for the correspond with the mine operation include with the drilling of the multiple coal bed methane gas wells on each drilling unit. D, if any of the order established or modified with the drilling unit will allow the well to be drilled with a coal seam and any coal owner with the area will to be covered with the drilling unit may be the object of establishment of the drilling unit upon coal objects of objection without superseding impairing with the bridging affecting the contractual rights obligation existing between coal and gas owners. The board shall make the determination according to provisions of the statute 45 to 1611 to 1612. E, the board will continue with the hearing at the next meeting with allow with further investigation, gathering, taking of the additional data for the evidence at the time when the hear over the not sufficient evidence of the board to determine the field of the boundary drilling unit size and shape, or allowable production. The board may enter for the temporary order establishing provision drilling unit field boundaries, allowable production, Order development of the pool pending with the receipt of the information necessary to determine the ultimate pool boundary spacing well of the pool, allowable production upon finding facts for the boundary pool with the drilling units of the pool, allowable production may be modified by the board. F. Unless otherwise provided by the board, where after application and its hearing established for the modified drilling of the pool boundaries has been filed with no additional well shall be permitted the board in the pool until the board has orders establishing or modifying the pool until the unit has been entered. G. After the board has issued field pool spacing over the agreed for the drilling unit, the pattern of the drilling units of the pool for the gas owner apply for the permit, otherwise indicate desire for the drill well, also for the drilling patterns, otherwise drilling with their potential extend the pool for the board may own its motion or motion any interested person require that they will be located drilled with the compliance provisions of an order affecting the pool. 1619. Alright, 1620. Pooling interest in the drilling units. A. The board, upon complete application for the gas oil, will enter for the order in pool and interest for the drilling unit for the development and operation thereof. The 1. 2 or more separately owned tract with embrace in the drilling unit. 2 for the separately the own interest for the part with the stuff of the drilling unit with those owners for the interest that have not agreed to pool the interest. 3. Separately owned tract with embrace for the minimum statewide spacing requirements of the statute 45-2-16-16. Have with no pooling order should be entered until the notice here requirements article has been satisfied. B. Subject to any contrary provisions contained in the gas oil lease regarding the property gas oil operation incident with the drilling the well. A. With a portion of an unit covered by the pooling order should be deemed with the conduct of the trust of the operation. Each for the track of the unit with a portion of production and allocated with the track covered by the pooling order shall be in the same proportion as the acreage of the track bear for the total acreage of the unit. C. After pooling order entered by the board pursuant with the provision of section shall one authorized drilling operation well will include the stipulation with all coal seams in the case for the coal methane well when authorized pursuant to clause 3 subdivision F2B with the statute 45-2-1631 subject to permanent provision and Article 3's 45-2-1629 and 10 sequence. 2 includes the time and the date with whom such order expires. 3. Designate gas well with the owner who authorized to drill the operator of the well, except in the case of the coal methane gas well, the designated owner operator shall possess right to conduct the operation, possess with the written consent of the owners of the right to conduct the operation at least 25% of the acreage included in the unit. 4. Prescribe the condition of the gas well owner may become participating operative the exercise of the right of the election of the subdivision. 7. 5. The establishing generally all reasonable conflict with including reasonable supervision with a fee between the participating operators, so that each of the participating operator may pay the same percentage of such of the cost of the acreage bear for the total unit acreage. 6. Require the non-leasing gas well owner provide with a reasonable action for the unit with the records submitted with the director and inspector. 7. The establishing proceed with the gas oil owner will receive the notice of the hearing, but it does not decide whether becoming the participating operator to elect 1 to sell the lease of his gas or oil's ownership to participating in operator. 2. For the enter into the voluntary agreement to sharing operation of the well with a rate with a mutually agreed to be by the gas oil owner and the gas oil operator authorized to the drill of the well. 3. Sharing of the operation of the well with the non-participating operator on carried basis after the proceeds allowable to share the equal following. A. In the case of the lease is tracked 100% of the share of costs allocable to the interest, or 2B. Case of the lease tracked 200% of share of such costs allocable to its interest. D. Any gas or oil owner who is identified with the location remain unknown for the conclusion with a hearing of the concern of the establishing pooling over the public known was given and deemed to be elected with the interest of the gas oil operator does the rate with the established by the board shall cause the established escrow of the account into unknown lesser share of the proceeds if it shall be paid for the health of the benefits such are escrowed proceed with the deemed the unclaimed property disposal of the pursuant of the provisions of Virginia the Disposition Unclaimed Property Act upon discovery of identified location of the unknown operator interest in the subject escrow under the provision subsection and is not subject to conflicting claim. Ownership designated operator shall within 30 days file with the Board of Petitions disbursement of the funds considered for the next available hearing. The petition shall include the detailed accounting all funds deposited to the escrow for the subject of provision of disbursement. Any person who does not make an election under the pooling order shall be deemed to have the least gas or oil interest to the gas well operator as pulling order provides. F, the gas owner and person with a disability under a disability application pulling order made in the position appropriately to circulate the report to appoint a guardian item ad litem pursuant to provision 8.01 pursuant to making selection provided in subsection in this section. G, any royalty overriding royalty reserved in the lease and is deducted with the non-participating operator's share of the production, not subject to the charged operating costs, separately calculated and paid to the royalty owner. 8. The board shall reserve all the disputes arising among gas oil operators regarding the amount of the reasonableness or operation cost of the board by regulation and establish allowable types of the costs may be shared in pooled gas or oil operations. 1620. 1621. Coal bed methane gas owners. No conveyancy, reservation, or expectation of the coal shall be deemed to include the coal bed methane gas. Nothing in this section shall affect the coal's operator's right to prevent coal bed methane gas safety and for safety purposes of the relief of the coal bed methane gas in connection with the mining operation. Provision of the section shall not affect any settlement, any dispute, or any of the judgment, government, order as to the ownership of the development of coal methane gas made or entered in prior to April 13, 2010. Alright, 1622, pooling with the interest of the coal bed methane gas while conflicting with the claims to ownership. A, if the conflicting claim with the ownership of the coal bed methane gas of the board upon application from the complaint with the challenge for the pooling interest of the X state in the coal methane gas give the knowing with the development of the operation thereof. The B, the addition of the statute 45-2-1620 with the following revisions. This shall apply with the other order provided in subsection A. 1. Simultaneously with the filing of the application from the gas line or owner applying for the order shall the notice of the pursuant of the provision 45-2-16-18 with each of the person identified with the application of the potential owner or interested in the coal bed methane gas underlying track with the subject of the hearing. 2. The B board shall cause establish escrow account with which the payment cost of the proceed with the attributable to conflicting interest for the deposit held with the interest of the claimant. 3. For the claim coal bed methane gas operator shall deposit the escrow amount any money paid by a person claiming the contest of ownership of the interest of the participating operating share cost of the pursuant of the provision statute 45-2-1620 and order of the board. 4. Coal bed methane gas well operator shall deposit the escrow account 1/8 of the proceeds attributed to the conflicting interest of the pubs plus all of the proceeds of the excess of the ongoing operation expense attributable to the participating with the non-participating operator provided in for under section 45-2-1620 or order of the board. For the board shall pay payment of the principal accrued the interest of the lesser accrued account fee from the escrow of the account fee clothing claimant only after 1. A final decision from the court for the competent jurisdiction adjudication of the ownership of the coal bed methane gas or between them is issued. 2. The determination is reached the arbitrator pursuant to 45-2-1623 or 3. For the agreement is reached among all claimants owning conflicting estates and tract in question or an undivided interest therein. Upon receipt of the affidavit of the conflicting with the claimants affirming the subsequent decision, termination, or the agreement, the designated operator shall, within 30 days of the file with the board and petition for the disbursement of the funds of the behalf of the complainant and claimants of the petition shall include the detailed account of all the funds for the deposit for the escrow of about the subject proposed disbursement. The amount will be paid with the conflicting claimants shall be determined on the basis of the percentage of the ownership of the interest of the collecting claimants as shown. Operator's supplemental filing made with the pooling order established an escrow account. B. The operator's record of the deposit attributable to the tracks which funds those of the requested C of the records of the escrow account with the coal methane gas drilling unit in the position of the disbursement plate for the first available the board docket. Funds shall be disbursed within 30 days of the board's decision and received by the department of all the documentation required by the board. Interest of any of the contents that have not been resolved with agreement of judicial decision shall remain in the escrow account. Any person who does not make an election on the pooling order of the deemed subject to the final legal determination of the ownership of the lease of his gas oil interest to coal bed methane gas well operators provided in the pooling order. That was 1622. Alright, 1623. Conflicting claims of ownership of the arbitrary of the board shall enter the order with the requirement of the material of the matter of the dispute of the ownership is remembered the arbitration for the north of the trick with the core of the jurisdiction of the majority. The subtract is located in one upon with the rent request for all of the claimants over the ownership coal bed methane gas related subtract with the owner statute 45-2-16-22 and upon receipt of an affidavit executed all such claimants with affirming that there is no other owner known surface owner of the gas, oil owner, coal owner, mineral owner, of the operative of the gas storage field, certified the state of the corporate commission to have the interest of the underlying subject track 3, after the hearing with the notice pursuant to subsection B, 45-2-16-18, and 4, upon the determination of the Department of Realization funds available to pay with the estimated cost of the attribution pursuant to the subsection F, for 30 days of the receipt of the notice of the board of the circuit court shall appoint an attorney to list maintained with the department pursuant to the subsection C, or with the discretion of the court, another attorney meeting the qualifications of subsection C with the prior to the employment with the arbitrator, particularly with the dispute with the attorney shall certify that the circuit court has not derived more than 10% of it as income during any preceding 3 years for any calamitous asserting ownership of the right subject track be affiliated to any of the immediate family membership of the claimant. If the attorney cannot provide such certification, shall notify the circuit court. A will be disqualified serving the arbitrator with a particular dispute. B, the department shall send with the notice of the claimant that determined that there are insufficient funds for the estimate of the cost of attribution for the person and pursuant to the subsection F, the claimant is made unanimously a grant may be an anonymous agreement proceed with the arbitration process notifying the board's notice agreement to bear cost to the extent of the insufficiency. Parties do not agree with the arbitration shall be delayed until the such funds are available. C, to be qualified with the arbitrator for the candidate who shall 1. be an attorney licensed with the Commonwealth, 2. to have at least 10 years of experience with the real estate law, including substantial expertise with the mineral title examination, 3. disclose to the board whether that he has engaged for the preceding 3 years by any personal matter subject to the jurisdiction of the board of the department. Under this chapter, the department shall solicit applications from the attorney meeting the qualifications set forth with the subsection maintain. List of the attorney qualifying arbitrator for you by circuit court of the department shall be updated with at least once annually if the maintains qualification. Each of the attorney who's not named appears on a list updated annually with his disclosure set forth in clause 3. Or D, the arbitrator shall determine the time and the place for the arbitrary hearing the cause of the written notice for the hearing shall be determined with each surface owner of the gas oil owner, coal owner, mineral owner, operative of the gas storage field certified by the State Corporate Commission to have an interest underlying with the track for the subject for the hearing parties shall be served personally by certified mail return receipt requested not less than 14 days before the hearing appearance of the hearing waived. Such parties right with the challenge no that any of the party arbitration have the right to representation before the arbitrator pursuant to statute 8.01581 is .05 or 8.15810. 1-6, the arbitrator may issue the subpoena with the intents witness with any of the production books of the record for the documents and other evidence. Administrative orders upon application of by the party arbitration permit with the taking of the disposition of the evidence the arbitrator shall hear with the determination controversy upon evidence consistent with the applicable law, notwithstanding with the failure of the party appearing with a hearing. Either the arbitrator shall issue the determination of ownership of the coal bed methane gas entitlement with the proceed with the help of the screw with the 6 months in order to board require matters submitted with the arbitration left with a longer period with the otherwise agreed to all the parties with the determination shall be written with the same with the board in each of the parties shall be notified required to give it in subsection D. Upon issuance of the arbitrary determination of ownership of such object availability of funds, the fee for the expense of the arbitration but not include cost of counsel engaged with the respectively claimants or any other clause for the claimant shall be paid with accrued interest for the general screw account funds. C, an arbitrary determination rendered pursuant to the subsection E shall be binding upon all of the parties upon request of any of the party. The arbitration determination may be the entry for the judgment with the circuit court responsible for the appointing the arbitrator under subsection A, and H upon application of the party of the arbitration determination or tender pursuant to the subsection E may be confirmed, vacated, corrected, or appealed pursuant to the grounds set forth in chapter 21, 8.01157 and sentence sequence of Title 8.01. That was 1623. Cut the tape there.